for this very flattering introduction. I somehow doubt your fame of being very rigid after what you have just said. Good afternoon, ladies and gentlemen, dear colleagues. Let me start by congratulating Mr. Maciej Janka and Professor Andrzej Olasz and all those who supported them on bringing back a comprehensive training on licensing and arbitration to the hospitable setting of Jagiellonian University in Krakow. It has already been proven to be a perfect match, as we heard from the Secretary General, Alexander Kresas. I would also like to express my gratitude to the organizers of this opening ceremony for inviting me to speak about the concept of party autonomy and its limitations in international commercial arbitration. I feel truly honored to have the opportunity to address you on this topic today. Before I delve into the details of the idea of party autonomy, I would like to mention what, quite unexpectedly to me, has become a source of inspiration for me in thinking about this topic. By pure coincidence, while preparing this address, I started reading, more or less at the same time, the most recent book by Professor Timothy Snyder, which was published earlier this month. It is titled On Freedom. As many of you know, Professor Snyder is a historian and a political philosopher from Yale University, specializing in nationalism, history of Central and Eastern Europe, history of the Soviet Union, and the history of Holocaust. I mentioned my reading of his recent book on freedom, as I discovered it helped me to structure my thinking about the concept of party autonomy in international arbitration, or in arbitration more generally. Professor Snyder starts by explaining what freedom is by referring to a distinction between a negative freedom and a positive freedom made by another historian and political philosopher, Isaiah Berlin, in his Cold War time essay on two concepts of liberty. As a side note, I need to mention that I have a very fond and vivid memory of this essay, as it evokes my university times, during which I attended a tutorial led by late Professor Marcin Król, an eminent Polish political philosopher and historian of ideas, whose first assignment given to students at the time was a critical analysis of this Isaiah Berlin's essay on two liberties. So Snyder repeats after Berlin that a negative freedom is a freedom from coercion and oppression by other humans. According to this negative conception of freedom, the wider the scope of activities in which we can do as we please, the freer we are. Of course, we can't all have unlimited negative freedom. The freedom of all needs to be limited to ensure the freedom of all. A positive freedom, in turn, is a freedom to envision the future and have the agency to shape it. Snyder labels freedom as the value of values, or if you wish, the value of the highest order, as it allows individuals to autonomously determine what other values they ought to follow, and allows all those other values to exist and prosper. There are various values worth realizing. However, sometimes it is impossible to reconcile them all at the same time. For example, says Snyder, you cannot be completely honest and completely loyal at the same time. Therefore, people need to make choices between values all the time. And it is an incessant human endeavor to navigate between various goods or various values. I can see a great deal of analogy between Snyder's conceptualization of freedom and its limitations, and the understanding of party autonomy and its limitations as developed in the jurisprudence in international arbitration. It is, of course, trite to say that party autonomy is the cornerstone of international arbitration. We all know this. This is what students of this training course will be repeatedly told over the next couple of months. But what exactly is party autonomy? First and foremost, party autonomy is nothing less but the party's freedom to shape the arbitration process and exercise significant control over it. This is where the analogy with Snyder's conceptualization of freedom comes handy in understanding what the role of party autonomy in international arbitration is. It is its value of values, or the most important foundational value. This is because, and I repeat after Snyder, it allows other values pursued in arbitration to exist and prosper. These other values include flexibility, neutrality, efficiency, privacy, just to name a few. Professor Jan Paulsen, in his well-known book, The Idea of Arbitration, has observed that, and I quote, "The ideal of arbitration is freedom reconciled with law. Acceptance of arbitration is a distinctive feature of free societies and is generally rejected by totalitarian states." Paulsen concluded that the argument in favor of arbitration is based on the premise that people are free to arrange their private affairs as they see fit, provided they do not offend public policy or mandatory law. Party autonomy has many facets. For starters, parties can choose between institutional and ad hoc arbitration. They can also choose legal rules applicable to their dispute, both substantive and procedural, or go as far as to opt for the rules which are not those of a given legal system, for example, lex mercatoria, or the principles of equity. Furthermore, parties can choose arbitrators, the ability which some hail as the highlight of party autonomy. Finally, the parties are free to tailor the arbitral procedure to particular circumstances of their dispute. The party's freedom to shape the arbitral procedure is recognized and protected by the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which permits refusal to recognize an arbitral award where a tribunal has failed to comply with the parties' agreed arbitral procedures. The extent to which parties can shape arbitral process is best illustrated by a famous quote by Richard Posner, allegedly the most cited legal scholar of all time and retired US federal judge, who wrote in Baravati versus Jokntal, Lyon and Ross as follows. This is one of my favorite quotes, although quite extreme, I would say. "Short of authorizing trial by battle or ordeal, or more doubtfully by a panel of three monkeys, parties can stipulate to whatever procedure they want to govern the arbitration of their disputes. This notwithstanding, and like freedom, party autonomy is not absolute or limitless. It has boundaries. Various legal, procedural, and policy considerations can restrict party autonomy in specific contexts. For example, the party's freedom to shape the arbitral process as they please is circumscribed by the minimum requirements set out in Article 18 of the Uncivil Model, which requires that the parties be afforded equal treatment and a fair opportunity to be heard. Furthermore, parties' right to appoint arbitrators is limited by the requirement that the arbitrator must be impartial and independent of the parties, unless the parties decide to waive this requirement. However, even then, there is a limit on the scope of the permissible waiver, as certain conflict of interest situations are non-waivable. This includes situations deriving from the overriding principle of natural justice that no person can be their own judge. Late Professor Emmanuel Gaillard has noted that while philosophical notions of autonomy and freedom are at the heart of the study of arbitration, similarly essential are the questions of legitimacy raised by the freedom of the parties to favor a private form of dispute resolution over national courts, to choose their judges, to tailor the procedures they deem appropriate, to determine the rules of law that will govern the dispute. From this vantage point, the limits to party autonomy may be perceived as a way to give legitimacy to the arbitral process. The more parties shape the arbitral process to look like proverbial trial by battle or ordeal, or by a panel of 3 monkeys, the less legitimacy it enjoys. The right balance must therefore be found between promoting flexibility of arbitration on the one hand, and on the other hand, ensuring its integrity as a method of resolving disputes in accordance with the rule of law, or otherwise the legitimacy of arbitration will be lost. On a more granular level, that is the one below the meta purpose of legitimacy of arbitration, limitations to party autonomy serve a whole variety of more detailed goals, like safeguarding fundamental principles of natural justice, morality, and public order, such as, for example, equality or the right to be heard, that aim to prevent unfair or biased outcomes. Other limitations connected with the issues of arbitrability aim at reserving certain types of disputes for state courts, because they touch on issues that affect not just the parties involved, but also third parties' interests or broader societal interests. And last but not least, limits to party autonomy are imposed to make sure that arbitral awards are enforced by state courts. So where to look for those limitations? By and large, the limits to party autonomy are set by public policy at the seat of arbitration or at the state of enforcement of an arbitral award. Furthermore, they can be found in mandatory provisions of the applicable law, substantive and procedural. Finally, they stem more and more often from private mandatory rules established by the arbitral institutions. Those limitations are the reflection of tensions or even conflicts between party autonomy and certain other values pursued in arbitration. You remember my comment on Snyder's describing the constant human endeavor of navigating between various conflicting values that cannot be all realized and fulfilled in 100% at the same time. So this is what happens in arbitration as well. Therefore, various arbitration stakeholders, including arbitrators, arbitral institutions, and state courts, face the challenge of reconciling such conflicting values by giving priority to party autonomy at one time or to other values some other time. I would like now to turn to some examples of those conflicts that occasionally arise between party autonomy and certain other values like efficiency of arbitral proceeding, equality in constituting an arbitral tribunal, protection of third-party interests. In this vein, I will discuss first some common tensions that occur practically on a day-to-day basis between parties' freedom to shape the arbitral proceeding on the one hand, and the powers and duties of arbitrators on the other hand. I will next turn to discuss some tensions that appear from time to time between party autonomy and so-called private mandatory rules, by which I mean the rules that arbitral institutions consider so essential to the service they provide that no derogation from those rules is accepted. I will also discuss the controversies surrounding the way arbitral institutions exercise their discretion in performing some of their functions, which sometimes goes as far as to override what the parties have agreed in their arbitration. Finally, tensions may arise between parties and state courts at the post-award stage with respect to the scope of judicial review of arbitral. Turning to the first group of conflicting values or tensions between party autonomy and powers and duties of arbitrators, the core question is here whether in the conduct of the proceedings, arbitrators must always follow the parties' wishes, or whether they can ignore them for the sake of, for example, efficiency or other important considerations. This is a very practical question that arises almost daily in arbitration practice. The usual answer to it is that party autonomy must prevail if the parties agreed to a certain procedural step, such as, for example, bifurcation of the proceedings, or to certain procedural timetable, or the manner in which evidence will be taken. However, there is a gray area where there may be situations in which party autonomy and the arbitrator's role collide. This may happen when the parties reach an agreement, but the arbitrators conclude that agreement to be unfair, inefficient, or otherwise inappropriate. Should they use the powers they are vested with to fulfill their procedural duties, or should they be loyal to the parties who provided them with those powers in the first place? In such uncomfortable circumstances, arbitrators find themselves really between a rock and a hard place. Among the various possible problematic situations, we could think of the following: requesting truly unreasonable time extensions, multiplying the number of written submissions beyond what is really reasonable, proposing an exaggerately high number of witnesses, while it is quite evident that the witness examination will not be effective. Although such deadlock situations are rare, when they occur, they trigger the question of which position should prevail. From a practical standpoint, seeking a balance between both positions seems to be the optimal approach. The arbitrator should be cautious in the exercise of their powers and, in principle, use them when the parties cannot reach an agreement. But when there is an agreement, it is hard to imagine a scenario where it would not represent, to some extent at least, an advantage for the parties. The parties are arguably the best to judge whether a solution that they propose serves their needs or not. Even when such an advantage may not be crystal clear or self-evident prima facie, their opinion should command some deference. Therefore, the arbitral tribunal should be cautious before it seeks to impose a rule at variance to that agreed upon by the parties. In deciding whether to make such an order, the tribunal should carefully consider the reasons underlying the parties' agreement, and only in really extreme situations try using its powers to limit party autonomy. Let me now turn to controversies surrounding arbitral institutions' incursions into the territory of party autonomy, or to what Professor Klaus-Peter Berger calls a party autonomy paradox. Professor Berger points out that, and I quote, while party autonomy can be freely exercised in choosing an arbitral institution and its rules, that choice may have a price in the form of limitations on that autonomy when it comes to the conduct of the proceedings under the chosen rules. By way of reminder, the arbitral model law reflects the vital link between the institutional arbitration and party autonomy. Article 2b of the model law provides, where a provision of this law leaves the parties free to determine a certain issue, such freedom includes the right of the parties to authorize a third party, including an institution, to make that determination. The fact that the parties, by choosing a specific arbitral institution, vest this institution with the performance of numerous tasks during the arbitration leads to two very important questions. First, are the parties bound by this institution's arbitration rules to the extent that they are considered mandatory by the arbitral institution? And second question, does the arbitral institution, in exercising the administrative discretion granted to it under its rules, have the power to overrule a procedural agreement by the parties? Replying to the first question about the parties' freedom to derogate from the rules that an arbitral institution considers to be mandatory, the outcome will be quite predictable, I think. The institution will simply refuse to administer the parties' arbitration. The ICC court, for example, would most certainly refuse to administer an arbitration in which the parties had agreed to opt out of the terms of reference procedure or the confirmation of arbitrators nominated by parties by the Secretary General, or of scrutiny of draft arbitral awards by the ICC court, all of them being distinctive features of ICC arbitration, not found in the rules of other major international arbitral institutions. This supervisory role of arbitral institutions is a natural consequence of a service contract concluded between the parties and the institution. If the institution is liable to the parties under the contract for a proper administration of the proceedings according to its rules, then the institution has a legitimate right to make sure that the parties do not evade those core provisions of its rules, which the institution considers essential for arbitrations conducted under its auspices. The arbitral institution's refusal to administer the arbitration has a considerable limiting effect on the parties' autonomy. However, that limitation itself is based on the parties' presumed will. When agreeing to arbitration under the rules of a given arbitral institution, parties are assumed to have accepted the mandatory rules contained in the arbitration rules as restrictions on their general autonomy to tailor the proceedings in the way they please. Consequently, if the parties faced with the institution's refusal to administer the arbitration decide not to terminate the arbitration, but to continue the proceedings without the administering services of that institution, the nature of the arbitration changes from institutional to ad hoc. In line with this view, the parties to ICC arbitration who had opted out of the ICC court's core prerogative under the ICC arbitration rules to confirm arbitrators nominated by the parties and to scrutinize the final award before it is served on the parties, to continue their arbitration as ad hoc proceedings and conferred on the ICC court the power to act as appointing authority when the ICC court declined to administer their arbitration. The limits on party autonomy set by the institution's refusal to administer the arbitration do not frustrate the parties' general intention to have their dispute resolved outside of the domestic courts, but only their choice as to how that alternative dispute resolution process is to be conducted. Turning to the second question about whether the arbitral institution's discretion in exercising its powers under the rules can override parties' joint will enshrined in their arbitration agreement, the best illustration of this problem is the arbitral institution's power exercised in the context of expedited arbitrations, where institutions often determine that the case will be decided by a sole arbitrator, even if the arbitration agreement provides for three arbitrators. The conflict between the discretionary power of the institution and the parties' arbitration agreements has been resolved so far differently by different courts. For example, the Singapore High Court did not regard the existence of the party agreement on a three-member tribunal alone as an absolute bar to the appointment of a sole arbitrator by the SIAC president. This is because the one-member tribunal was a fallback rule provided for in the SIAC rules, Article 5.2b, thereby indicating a strong preference of this institution for that option in the interest of procedural efficiency. However, another court, the Shanghai Court, seized with the enforcement application considered the aspects of procedural efficiency, even if enshrined in the institutional fallback rule, to be unable to trump the autonomy of the parties. In view of the significance of this judgment by the Shanghai Court and its reference to the primacy of party autonomy, the SIAC in 2016 addressed this question, and now the rules, the SIAC rules stipulate, by agreeing to arbitration under these rules, the parties agree that the rules and procedures set forth in Rule 5.2 shall apply even in cases where the arbitration agreement contains contrary terms. The ICC arbitration rules adopted a similar approach. Article 30, Section 1 of the ICC rules states that by agreeing to arbitration under the rules, the parties agree that this Article 30 and the expedited procedure rules shall take precedence over any contrary terms of the arbitration agreement. More specifically, Article 2, Section 1 of Appendix 6 to the ICC arbitration rules provides that the ICC court may, notwithstanding any contrary provision of the arbitration agreement, appoint a sole arbitrator. That solution is indeed a remarkable outcome, given that it leads, at least in Professor Berger's view, to the unique and paradoxical situation that the parties, by referring to the SIAC rules or the ICC rules, specifically agree to invalidate their own agreements, insofar as they are contrary to the expedited procedure provisions within those rules. It is noteworthy that some other institutions have taken a different pro-autonomy approach to the resolution of the conflict between implementing the will of the parties and the need for procedural efficiency in expedited proceedings. By way of example, Article 41, Section 2 of the Hong Kong International Arbitration Center's rules provides that if the case is to be conducted pursuant to the expedited provisions, the case shall be referred to a sole arbitrator unless the arbitration agreement provides for 3 arbitrators. And if the arbitration agreement provides for 3 arbitrators, Hong Kong International Arbitration Center shall invite the parties to agree to refer the case to a sole arbitrator. However, if the parties do not agree, the case shall be referred to 3 arbitrators. A similar approach has been adopted in Article 42, Section 2 of the Swiss rules. Yet another dimension of arbitral institutional discretion in exercising their functions, which at the same time limits the parties' rights to choose arbitrators, has been sanctioned by courts, at least French courts, in the well-known Dutko case and most recently in the Vidatel case. In the latter case, 4 partners holding 25% stake in their joint venture included in the shareholders' agreement an arbitration clause, providing for an ICC arbitration seated in Paris. Pursuant to the arbitration agreement, the dispute was to be decided before a panel of 5 arbitrators, one to be designated by each out of 4 shareholders. And the 5th arbitrator was to be designated by the other 4 arbitrators, provided, however, that no agreement between the arbitrators designated by the parties is reached. The independent or the 5th arbitrator shall be designated by the president of the ICC. One of the shareholders who sued its 3 remaining partners proposed that the arbitral tribunal should be composed of 3 arbitrators instead of 5, because of the convergence of interest between the other 3 shareholders. It reasoned that appointing 5 arbitrators would result in the tribunal being constituted by a majority of arbitrators appointed by parties whose interests would be aligned against claimants, which would be against the principle of equality. Therefore, claimants appointed 1 arbitrator and requested the other 3 respondents to propose 1 arbitrator jointly. However, the other 3 respondents rejected this proposal and each appointed 1 arbitrator as per the arbitration agreement. And they said, well, the equality rule is preserved because each shareholder has an equal right to appoint 1 arbitrator. Considering the disagreement between the parties, the ICC invited the parties to agree on a different method of constituting the arbitral tribunal, but was unsuccessful. Therefore, the ICC court dismissed the parties' nominations and appointed all 5 tribunal members under Article 12.8 of the ICC arbitration rules. Subsequently, the ICC court dismissed a disqualification application against the 5 arbitrators it had appointed. The respondents who lost this arbitration subsequently tried to set the award aside for it having been rendered by improperly constituted arbitral tribunal. The French Cour d'appel dismissed this objection, stating that the principle of equality between the parties is not only to be assessed at the time of the conclusion of the arbitration agreement, so at the time when each had an equal right to appoint one arbitrator, but also on the day the dispute had arisen, taking into account the claims and interests of each of the parties. Subsequently, the French Cour de Cassation, the French Supreme Court, which dismissed the appeal against this Court of Appeals judgment, held that since all the disputing parties were deprived of the right to choose their arbitrator, the equality between them was preserved. In the limited time that I have, I will not elaborate on the third group of conflicts between party autonomy to shape the scope of judicial review of the arbitral awards and other values considered to be part of the public policy at the seat of arbitration. Just to only mark this problematic, the key question here is to what extent the parties can modify the review of the award made by the national courts at the seat of the arbitration. Some parties may wish to exclude entirely the possibility to seek a set-aside at the seat, contractually, of course. Alternatively, the parties may wish to limit the review by national courts at the set-aside stage by specifically excluding or implicitly waiving certain grounds. And there's also a third option. Parties may sometimes desire to have an extended review by the national courts at the seat. There are significant differences in the approach to this conflict between values in various jurisdictions. The differing views in this area may be attributable to the different assessment of the competing public policies at play. For instance, in some jurisdictions, for example, Switzerland, set-aside waivers are only open to non-local parties, having no link with the seat. France, in turn, allows full set-aside waivers, but refuses to enforce partial waivers. While the US Supreme Court in the Whole Street case determined that the parties' agreements for expanded review, judicial review of an arbitral award, was unenforceable. Just a year earlier, so in 2007, the German Supreme Court reached the opposite result and reversed its prior case law in this respect. So completely different approaches, completely different outcomes. Clearly, the policy of protecting third parties and public interest as opposed to parties' interests only at the post-award stage is an important concern for national courts. In conclusion, I would like to say that a discussion on party autonomy and its limitations never ends, given that arbitration laws and arbitration rules constantly evolve. While the primacy of party autonomy, which, to borrow from my early remark on Snyder, is the value of values pursued in arbitration, is a well-established concept. The question of where its limits are is not always clear, not finally set in scholarly writings or state court decisions. I wish the participants of the upcoming ICC comprehensive training very many fascinating and thought-provoking discussions on this and other topics. Thank you very much.